PLA with myself, Bruno, and Nick. And we've got two questions for our gentlemen again today. And then the first question has to do with the OTP, which Nick will deal with. And then the second one has to do with trusts. So the first question, Nick, goes as follows. It is from Anonymous on our Facebook page. She states that she signed an OTP for a house in the township in August 2022, and she first had to wait for 6 months for a letter of executorship, which the agent informed her that it's not going to be issued once she actually signed the OTP, as the wife was married in kind of property. She's been waiting since then for building plans from that seller, which the bank is requesting from her. This has obviously been a frustrating experience for her, and she would like to know if she can actually cancel the OTP, and if she does that, what will be the implications of that be?
Okay, perfect. So in terms of a question like this, obviously our writer has written in, they've said that there's a signed OTP that's now gone out and there's an agent of some kind being used in the circumstances. So the most important thing to understand about transfers when it comes to immovable property is that it is one of the very specific transactions within South African law that requires that a written document is used and that it is signed by the parties who are contracting into this particular arrangement. Okay, so for most commercial transactions that people go through within our economy, a written contract is not necessarily a requirement. Okay, if you think about the fact that you go to the shops every day and you go buy things from the shops, there is a contract that comes into place, but it doesn't require a written element to it. The reason that there is a requirement for written element for immovable properties is obviously because of the nature of the contract. This is something that's quite substantial. It's probably the most substantial contract that an individual goes through in their normal life within South African law, and so it's something that is highly regulated and something that we need to be very certain. Okay, so a written contract is required in the circumstances. And that written contract sets out the various circumstances, what happens in the particular contract, okay, relating to payment terms, when payment is supposed to be done, how payment is supposed to be done, what happens if something doesn't happen within that particular transaction, okay. It all needs to be reduced to writing and contained within the sale agreement, okay. So obviously, this is a slightly complicated transfer because our writer has said that there was some necessity to get letters of executorship in respect of property. It seems to me that there has either been a person who is deceased who owned the property previously. Alternatively, it could be someone who's declared insolvent or something to that effect. But letters of executorship would be needed in the circumstances because they are the ones who then act on behalf of the estate. That has now been done. Okay. And now they need to continue with transfer in the circumstances. So in respect of this question, you're going to have to look at the written document that's that's been signed between the parties. Okay? That is going to provide what needs to happen in this particular transaction. And what it should have is a breach clause of some kind. Okay. Unfortunately, we don't have the benefit of having this particular OTP. So I can only speak from a general standpoint, but that OTP is going to have certain provisions of when things are supposed to happen. If you consider the OTP, okay, and I will say to our writer, seek legal assistance, make sure you speak to an attorney, contact one of our officers so that we can have a look at the document for you. If there's been some sort of breach, okay, then you are going to be able to put the other side on terms, okay. It's going to require a breach notice. You cannot cancel a immovable property sale agreement without giving a breach notice of 30 days in terms of the Alienation of Land Act. So that's the very minimum that you can expect. Okay. But that's going to provide a 30-day period for any breach that might have occurred in the transaction to be remedied. Okay. If it isn't remedied within that 30-day breach period, you'll have the ability to cancel the agreement. And then again, depending on what the terms of the OTP are, okay, will dictate what the consequences are. So there are a number of different consequences that can happen depending on what's been put in the OTP. Things like rookwoop, which is basically a predetermination of damages, which is retained by one party or the other. Those are terms that have to be in the written OTP in order to be enforceable. Again, you're going to have to consult the OTP. So, writer, please speak to an attorney to see if they can assist you in this particular regard. And I think, yeah, I think that's all of the question. I think I got everything.
Okay. Okay. So thank you very much, Nick. So yeah, as you said, so the OTP definitely with regards to this, she should get in touch with one of our attorneys so we can do a proper OTP review for an advisor based on the OTP.
Sorry,
Bruno,
I remember what I wanted. I remember what I wanted to say. There's one other thing.
Okay, yeah. So maybe then Nick, you can just add, and then Bruno, you can jump back on.
Sorry. I don't know if I'm going to say the same thing that you suggested, Bruno. The other thing that I suggest for a lot of clients, because we do have conveyancers who get caught up in processes or maybe slow or don't do this. The other reason that I suggest go and speak to your own attorney is if you get yourself an attorney who's a separate attorney, someone who's proficient in conveyancing. Remember, any attorney who is a conveyancer advertises it on their letterheads or on their website. If they don't have the provision of conveyancer, they're not entitled to do this, okay? Because they can't actually conveyance. But what you can do is employ an attorney on what's called a watching brief, okay? Watching brief is a very powerful tool. Basically, you get a third-party attorney to look into the transaction to make sure that the attorney who's actually charged with the conveyancing is not delaying the process in any particular way, and they drive the process. Unfortunately, it does mean that you've got to pay for the services of a third-party attorney to make sure the transaction goes through. But in circumstances like this, I mean, you've already been waiting now, 14 months for the transaction. It might be worth paying another attorney a little bit of money to make sure that they push that transfer through as quickly as possible.
So it was something similar, exactly something similar to that. So we experience these type of transactions all the time, unfortunately, especially when it comes to deceased estates. And I think we've done videos on this numerous times. So deceased estate is notoriously known for taking absolute ages to pass transfer. And the problem is that estate agents regretfully don't actually understand what the process is. So when we train estate agents on the process, there is a lot of shock and horror to the fact that, oh no, the master loses the file at least 5 times before you get those letters of executorship. So that alone, to get letters, could take like 9 months. Joburg, you can't get anything out of Joburg, right? So that's already 9 months. Once that happens, the executor actually needs to do certain things, need to do the L&D account. Now, if the property gets sold, as an example, by the executor, but it's subject to either approval by the beneficiaries or approval by the master if the beneficiaries don't approve. Now, if the beneficiaries are minors, now it's the next question that you need to look at and go, oh, but if they're minors, is the master allowed to approve on their behalf? Is there certain value that needs to look at? Again, you're going back to the master document, gets lost. Takes a period of time. So estates are a great place to find good deals if you're willing to wait. But be very careful because it does take notoriously long. And on something that Nick said, though, like watching brief, very important. I've done plenty of watching briefs when it comes to estate deals, especially large estate deals for developers where they're trying to look at this property and control it. So if you're controlling the transaction or if the conveyancer is controlling it, bear in mind, depends who's doing it. Sometimes with estates, you get the executor that is also the conveyancer. So to a certain degree, sometimes you find that conflict there. So if you get your own attorney to act and take care of your interests, bear in mind, number one, breach terms, exactly what Nick said, depends on the type of contract. So obviously, if it's an installment sale agreement, for example, there's certain fixed timeframes that you need to look at. Normal contracts work differently. Just make sure that you watch these. One big problem that I have with the states, which is where I'm heading now, is it says there that transfer needs to be passed, but it doesn't say by when, it doesn't say how. So then the question becomes reasonableness. Yeah. And this, unfortunately, is a very abstract concept that no one quite has pinned down an answer to. So is it reasonable that the estate is taking this long? Well, it's certainly not the seller's fault because it's the master's fault. So reasonable from his perspective, yes, he's done everything he has to. The fact that the master's office is ineffective is not his fault and it's not unreasonable. So be very careful when it comes to trying to cancel based on breach in situations where the seller hasn't actually done anything to be in mora. Yeah, but that's pretty much what I wanted to mention with the states.
Yeah. Right. So thank you very much, gentlemen. And once again, to the viewer, we will encourage that they do get in touch with one of our attorneys so we can actually assist them.